Good afternoon and welcome. My name is Jamie Goodson. I'm the Director of the Division of Consumer Compliance Policy and Outreach here in NCUA's Office of Consumer Protection. I'll be the moderator for today's webinar. This webinar is designed to highlight improvements to NCUA's Consumer Assistance Center's complaint handling process and also to discuss effective credit union fair lending oversight practices. First, a note. The information contained in this presentation is for informational purposes only and is provided as a public service and in an effort to enhance understanding of the statutes and regulations administered by NCUA. It expresses the views and opinions of staff of NCUA and is not binding on NCUA or NCUA board members, and any representation to the contrary is expressly disclaimed. Now we'll turn to some administrative matters before we get into the substance of today's subject. I have a few administrative announcements related to the functionality of the webcast. First, please ensure the volume of your computer is turned up so you can hear the webcast. If you have trouble viewing a slide, click on the Enlarge Slides button on the bottom of the console. Also, please be sure to allow pop-ups from the website. A screen resolution of 1024 by 768 or higher will allow you to see the slides appropriately. That's 1024 by 768. Note that this webinar is being closed captioned. To use the closed captioning feature, click on the CC widget button, which is a gray button on the bottom of your console. You can download a copy of the presentation slides by clicking on the Resources widget button, which is a green button on the bottom of your console. Now, I know a lot of you have questions. You can submit a question at any time during the webcast in the Submit Question box on the lower left area of the console window. We've set aside time at the end of today's presentation to address questions. All questions we do not answer during the live webcast will be compiled, and we will post written responses to questions on fair lending on the Fair Lending Compliance Resources page of the Consumer Compliance Regulatory Resources webpage. That can be found on ncua.gov. If there are any NCUA staff attending this webinar, you can charge authorized time to participate or review the archived webcast to time code 42. For everyone, the webcast will be archived for on-demand viewing in approximately 3 to 4 weeks after the live event. And a media advisory will be issued when the archive is available. Now to our presenters for today. Our first presenter will be Gail Laster, who is Director of NCUA's Office of Consumer Protection. Next, we will hear from Morgan Rogers, who's Director of OCP's Division of Consumer Affairs, and then Matthew Nixon, a Program Officer in OCP's Division of Consumer Compliance Policy and Outreach. First, Gail will provide an overview of the agenda for today's presentation.
Thanks, Jamie, and good afternoon, everyone. We all know there has been a lot of activity in the consumer protection space in recent years. And as a result, credit unions are enhancing their compliance programs, and understandably, they are focusing on how they handle consumer complaints implicating consumer protection law. Now, regarding today's agenda, we will discuss how OCP has implemented new complaint resolution procedures that improve and streamline how the agency handles consumer complaints involving federal consumer financial protection laws and regulations. These changes have obvious implications for how credit unions structure their complaint handling process. For our second agenda item, we will discuss effective fair lending oversight using examples noted in NCUA's fair lending examination and off-site supervision contacts. Topics will include treatment of income received from public assistance programs, joint applications, co-signers, and third-party oversight. Finally, this afternoon, we will talk about standards that have been developed for determining whether a practice is unfair, abusive, or deceptive. And now at this point, I will turn the presentation over to Morgan Rogers to discuss handling of consumer complaints. Morgan?
Thank you, Gail. As mentioned earlier, I'm Morgan Rogers, Director of the Division of Consumer Affairs. The division is responsible for consumer complaints, overseeing the Consumer Assistance Center, financial literacy, and the consumer website, mycreditunion.gov. In this webinar, I will provide an overview of the NCUA Consumer Assistance Center's improved process for handling consumer complaints. First, I will explain the NCUA Consumer Assistance Center's function, and then I will go into the improved process for handling consumer complaints and technology changes to accommodate the new process. The Consumer Assistance Center is administered by OCP's Division of Consumer Affairs. NCUA's Consumer Assistance Center is responsible for addressing consumer complaints involving federal credit unions with total assets up to $10 billion, and in certain instances, federally insured state-chartered credit unions. Complaints involving matters that do not fall within NCUA's purview are forwarded to either the appropriate state supervisory authority or federal regulator for disposition. The Consumer Assistance Center receives complaints online and by fax and regular mail. NCUA's consumer protection website, mycreditunion.gov, hosts the online Consumer Assistance Center and provides access to complaint forms and information about the Consumer Assistance Center complaint handling process. The Consumer Assistance Center introduced improvements to its consumer complaint intake process to assist both the credit union and the consumer in resolving each consumer complaint and streamlining the complaint handling process. These improvements involve two distinct phases. One, attempted resolution by the credit union as appropriate, and investigation by the Consumer Assistance Center when necessary as the second phase. These new procedures seek to provide the appropriate credit union personnel with written information about the consumer's concerns and sufficient time to attempt to resolve the situation before the Consumer Assistance Center begins its investigation of the matter. The changes in the Consumer Assistance Center handling of consumer complaints was implemented gradually over the last several months. This extended implementation time period allows credit unions with sufficient opportunity to become familiar with the Consumer Assistance Center new procedures and make any necessary adjustments to their compliance management systems and complaint handling process. Now we'll talk about this distinct phases. Phase 1, which is attempted resolution by the credit union. In this initial phase, the Consumer Assistance Center assigns a unique identification number or case number to each complaint it receives to facilitate ease of reference. The Consumer Assistance Center then forwards the complaint and any documents provided by the consumer in support of the complaint to the chairman of the Federal Credit Union's Supervisory Committee, or in the case of some federally insured state-chartered credit unions, the Audit Committee, with a copy to the credit union's CEO. The Supervisory Committee, or Audit Committee, will then have the opportunity to review and, if appropriate, attempt resolution of the matter within 60 calendar days of the date of the forwarding letter. The Consumer Assistance Center also sends an acknowledgement letter to the consumer indicating that the complaint was received and forwarded to the credit union in an attempt to resolve the matter. Specifically, during the 60-day period, the Consumer Assistance Center recommends that the credit union take the following steps in attempting to resolve the complaint. Review the complaint in accordance with suggestions detailed in the attached OCP guide, Responding to Consumer Complaints, which is attached to our letter to credit unions that was published in June of this year. Communicate directly with the consumer as needed and appropriate, and respond in writing to the consumer with a copy to the Consumer Assistance Center, referencing the case number and indicating whether the credit union has been able to resolve the matter. However, it is important to note, the Consumer Assistance Center may begin a formal investigation of the matter, or it will initiate phase 2 of this process, if the Consumer Assistance Center does not receive any written response from the credit union within the 60-day time frame. The credit union notifies the Consumer Assistance Center in writing that it has been unable to resolve the matter with the consumer, or the consumer disputes the resolution of the complaint by contacting the Consumer Assistance Center in writing within 30 days of the date of the credit union's response letter. Now we'll discuss phase 2, or the investigation phase. Phase 2, or the Consumer Assistance Center investigation. In this second phase, the Consumer Assistance Center sends a letter to the chairman of the Federal Credit Union's Supervisory Committee, or again, in the case of a federally insured state chartered credit union, the Audit Committee, with a copy to the credit union's CEO. The letter includes the consumer's original complaint and any documents provided by the consumer in support of the complaint. It indicates that the Consumer Assistance Center is investigating the complaint and requests a written response to the Consumer Assistance Center about the matter within 30 calendar days from the date of the letter. And to state again, the Consumer Assistance Center may begin its investigation only if the matter is not resolved and in the other two circumstances listed on the current slide. So again, if they're not resolved, or we do not receive a response within the 60-day time frame, or the consumer disputes the response. The Consumer Assistance Center also sends a complaint or a letter to the consumer indicating that it has begun an investigation of the complaint. NCUA's Supervisory Committee Guide for Federal Credit Unions details the appropriate procedures for federal credit unions handling of consumer complaints, including their receipt, investigation, and documentation. Section 4.12 of the guide indicates the need for the Supervisory Committee to review pertinent records, credit union procedures and practices, and, where appropriate, take corrective action. Also available is the letter to credit unions 15-CU-04, as well as our coming soon, our Consumer Assistance Center portal user guide for credit unions. When the Consumer Assistance Center receives the Supervisory Committee's response, it reviews the response to ensure it adequately addresses issues raised in the complaint and that the actions taken, if any, are consistent with federal financial consumer protection laws and regulations. If the federal credit union did not address all of the consumer's concerns in its response, or there are remaining questions involving federal financial consumer protection issues, the Consumer Assistance Center will request additional information and or clarification from the credit union and notify the consumer that the complaint investigation is still ongoing. When the credit union adequately addresses and the Consumer Assistance Center analyzes all issues associated with the complaint, the Consumer Assistance Center will notify the consumer and the credit union of one of the following potential outcome determinations. 1. The complaint does not involve a federal financial consumer protection law or federal consumer compliance regulation for which NCUA has enforcement authority, and therefore the Consumer Assistance Center has closed its case in this matter. 2. The complaint is the subject of a pending lawsuit, and therefore the Consumer Assistance Center has closed its case in this matter. 3. The credit union has resolved the complaint with the consumer, and therefore the Consumer Assistance Center has closed its case in this matter. 4. The credit union's actions in this matter either did not violate or were not inconsistent with a federal financial consumer protection law or federal consumer compliance regulation, and the Consumer Assistance Center has closed its case in this matter. Or 5, the credit union's actions in this matter either violated or were inconsistent with a federal financial consumer protection law or federal consumer compliance regulation for which NCUA has enforcement authority. To the extent NCUA has any supervisory concerns about the credit union's actions, NCUA will follow up directly with the credit union to resolve them and ensure compliance with the applicable law or regulation. When a complaint is received by the Consumer Assistance Center, the complaint is assigned a complaint status. There are 5 total types of complaint statuses. The complaint status is determined by the Consumer Assistance Center. In Phase 1, those statuses are new, pending initial review, which means the Consumer Assistance Center is reviewing the complaint to determine if NCUA has jurisdiction over the matters outlined in the complaint. The second Phase 1 status is pending attempted resolution. The Consumer Assistance Center has determined that the matter involves a federal consumer financial protection law or regulation that NCUA enforces and has sent the complaint to the credit union for attempted resolution. In Phase 2, we have the status of open for investigation. The Consumer Assistance Center has determined that the complaint involves a federal consumer financial protection law or regulation that NCUA enforces and has begun its investigation of the matter. There are two closed statuses indicating the complaint has been closed. The first one indicates the complaint has been closed by the Consumer Assistance Center because the matter has been resolved, or the Consumer Assistance Center has completed its investigation of the complaint, or the complaint is the subject of a pending lawsuit. The second closed status is closed as referred, meaning the complaint does not involve a federal consumer financial protection law or regulation that NCUA enforces. Depending on the nature of the complaint, the matter has been referred to the appropriate NCUA office, federal or state government agency for review and handling, such as the Consumer Assistance Center will take no further action. The third and final phase of our process is the appeal phase. In the appeal phase, the credit union and consumer may appeal the Consumer Assistance Center determination and may request that the director of the Division of Consumer Affairs review the Consumer Assistance Center determination of the complaint. This appeal of the determination should be in writing and received by the director of the Division of Consumer Affairs within 30 days of the date of the Consumer Assistance Center determination letter. Thereafter, as part of this independent review process, the director of the Division of Consumer Affairs may seek additional information from the consumer or credit union before making a final determination. While we encourage the appeal process through the director of the Division of Consumer Affairs, consumers and credit unions continue to have the right to file a complaint with the NCUA Ombudsman, who reviews consumer complaints and recommends possible solutions. The Ombudsman assists in resolving problems by helping the complainant define options and by recommending actions to the parties involved. All right, from here we'll move on to the technology. On the screen now you'll see the new Consumer Assistance Center portal for consumers and credit unions. This new portal will be accessible under the Consumer Assistance Center tab at the top of mycreditunion.gov's homepage. So if you navigate to that homepage, you'll see the Consumer Assistance Center tab. And then on the left-hand side, there are a number of options to use the portal, whether that's logging in or finding an answer in our knowledge base. Just some notes about the portal. The portal only contains complaints submitted to NCUA as of August 21st, 2015. It went live for consumers to use on September 10th, and we will grant credit unions the opportunity to use the portal very soon. Credit unions should note that the use of the portal is voluntary. Those credit unions who would like to gain access also must first register. So NCUA is using a phased-in approach for providing access to the Consumer Assistance Center portal. As I said before, the Consumer Assistance Center portal went live in September for consumers, and we will start providing access to credit unions starting in November. And again, you're not required if you're a credit union to use the portal, and it's voluntary. The information contained in the portal is also not accessible by the public. First and foremost, the portal was created to assist credit unions with receiving correspondence from the Consumer Assistance Center about complaints concerning their credit union, sending responses and complaint information, and also checking the status of complaints filed with the Consumer Assistance Center. So when you log into the portal, those of you who choose to use it, the statuses we read before, you'll see those outlined in the view of the portal, walking you through where the complaint is with NCUA, so you can always keep track of where we are in the process. Another important notice, the online portal only contains complaints submitted to the NCUA Consumer Assistance Center as of the portal's August 24th, 2015 implementation date. So if you need information regarding cases or want to communicate with us regarding cases prior to that August 24th, 2015 implementation date, including the case status, you can call the NCUA Consumer Assistance Center at 800-755-1030 Monday through Friday, 8 a.m. to 5 p.m. Eastern. And for additional information about the Consumer Assistance Center complaint process that we've just discussed, including a list of recommended practices in handling consumer complaints, please see the NCUA June 2015 letter to credit unions, 15-CU04, Improving the Process for Consumer Complaints, and the accompanying OCP guide that was embedded in that document entitled Responding to Consumer Complaints. In addition, the NCUA Consumer Assistance Center, when we receive a request by credit unions to register to use the portal, we have created a user guide that we will send to you on how to navigate the portal, and it's called NCUA's Consumer Assistance Center Portal Credit Union User Guide. That will also be available on ncua.gov once the portal is released for credit union use. And the user guide contains step-by-step directions and computer screenshots on how to use the portal. So you can always have that handy the first time you decide to log in. And one last note, if the credit unions that elect not to use the portal can continue to communicate with the NCUA Consumer Assistance Center by email at consumeraffairs@ncua.gov and via postal mail. However, if the communication contains sensitive information, so if you're sending a response and it contains sensitive information, credit unions should take appropriate precautions to send that information in a secured format. Our portal is secured, but it is the credit union's responsibility to secure its communications outside of the portal. And finally, we understand that credit unions should take a role in their compliance management systems by being responsible, being responsive, and organizing and retaining and using complaint information, again, responsibly. As member-owned financial cooperatives, credit unions have a strong interest in managing compliance and reputation risk. A critical element of a strong compliance management system is establishing written policies and procedures to record, categorize, analyze, investigate, resolve, and respond to complaints in an appropriate and timely manner. A well-planned, implemented, and maintained compliance management system is a sound business practice to prevent or reduce regulatory violations and inconsistencies, as well as protect consumers and provide cost efficiencies. An effective compliance management system allows the credit union's management and employees to understand a credit union's compliance responsibilities and incorporate compliance requirements into a credit union's business processes. It ensures that compliance responsibilities and requirements are carried out, corrective actions are taken, and tools, systems, and materials are updated as necessary. Other important elements of a sound consumer compliance management system include board and management oversight, a formal written compliance program that consists of policies, procedures, training, monitoring, and prompt handling of consumer complaints, and auditing the compliance program. Your credit union's internal consumer complaint handling process should include procedures that provide for the documentation of complaints received and actions taken to address them. Your credit union should establish channels to receive a consumer complaint and inquiry, such as telephone numbers or email addresses dedicated to receiving this type of correspondence. After reviewing each complaint and conducting an investigation of the matter, your credit union should provide a written response to the consumer. For a list of recommended practices, again, in handling consumer complaints, see the previously mentioned OCP guide, Responding to Consumer Complaints, which is part of that letter to credit unions, 15-CU04, that's available at ncua.gov. Your credit union's response should address all issues raised in the complaint and explain its actions and decisions in the matter. In addition, your credit union should take corrective action as necessary and evaluate complaint trends to identify and correct systematic compliance problems. Although both management and employees are responsible for maintaining a sound compliance management system, the appropriate credit union personnel responsible for overseeing the complaint handling process are the supervisory committee members for federal credit unions and audit committee members or their equivalents for federally insured state chartered credit unions. Once again, to access the Consumer Assistance Center portal, you'll need to register with NCUA via email to consumeraffairs@ncua.gov, and the portal will be able to be found on the Consumer Assistance Center tab on mycreditunion.gov. And lastly, we have our Contact Us page. If you have questions about the portal or you have questions about our new complaint process, please feel free to give us a call at 800-755-1030. You can also write us at NCUA, or you can send us a fax at 703-518-6682.
Thanks, Morgan. Now we're going to move on to our next topic, and we're going to hear from Director of the Office of Consumer Protection, Gail Laster. Gail?
Thanks, Jamie. First, I'm going to discuss NCUA's Fair Lending Program, which is separate from NCUA's Safety and Soundness Examination Program and includes both examinations and off-site supervision contacts. Then Program Officer Matt Nixon will discuss observations NCUA analysts have made in evaluating compliance with fair lending laws. Now, under the Dodd-Frank Wall Street Reform and Consumer Protection Act, supervision authority in connection with compliance with federal consumer financial laws is based on a credit union's asset size. NCUA supervises and examines federal credit unions with assets of $10 billion or less for compliance with fair lending laws. NCUA enforces the Equal Credit Opportunity Act, or COA, in federal credit unions and HMDA in all federally insured credit unions. NCUA assesses compliance with its regulation under the Fair Housing Act in its fair lending examinations. The Department of Housing and Urban Development, HUD, and the Department of Justice, DOJ, have authority to enforce the Fair Housing Act. Now, this Consumer Financial Protection Bureau, or CFPB, supervises, examines, and has primary enforcement authority over credit unions with more than $10 billion in assets through CFPB's Office of Supervision and Enforcement and its Office of Fair Lending and Equal Opportunity. CFPB has exclusive rulemaking authority with respect to ACOA and HMDA. HUD has the primary responsibility for interpreting and enforcing the Fair Housing Act. Also, any pattern or practice of lending discrimination must be referred by NCUA to CFPB and other federal banking agencies to DOJ or the U.S. Department of Justice. And in carrying out its responsibilities, NCUA works collaboratively with DOJ, CFPB, and HUD to enforce federal fair lending laws. Now, to turn to the specifics of our fair lending and examination program, NCUA conducts on-site fair lending examinations and off-site fair lending supervision contacts. In the year 2015, NCUA plans to conduct 25 fair lending exams and 50 off-site supervision contacts. NCUA generally notifies federal credit unions about an upcoming fair lending examination or supervision contact at least 30 days beforehand and requests specific materials needed to evaluate compliance with fair lending laws. Our analysts are in contact with credit union staff throughout the process to address questions and provide feedback. Now, the fair lending examinations involve an extensive review of credit union compliance with fair lending laws. We follow the interagency fair lending examination procedures on a risk basis, which may include extensive transaction testing. Supervision contacts are a review of the credit union's fair lending compliance management system without any transactional testing. And although ratings are not assigned, a report is written and an exit briefing is conducted to discuss results and recommendations for your credit union. Now, in terms of selecting credit unions for fair lending exams and supervision contacts, NCUA considers a variety of factors. One factor is status as a HMDA data outlier. For this analysis, we focus on HMDA data, on application denials, and loan pricing. Another factor is prior regulatory violations, including violations of ACOA and the Fair Housing Act. We also consider general compliance risk. If a credit union has a high compliance risk rating due to lending violations, we would consider a fair lending exam or supervision contact. Another key factor is recommendations from field examiners based on observations made during their examinations. In addition, we consider complaints from members and whistleblowers focusing on trends and allegations of discrimination. And by reviewing a credit union's compliance management systems and through transactional testing, we determine compliance with fair lending laws. But we also educate credit unions about fair lending laws to help them improve their compliance. Now, in conducting fair lending exams, as I mentioned earlier, NCUA uses the interagency fair lending examination procedures developed jointly in 2009 by federal member agencies of the Federal Financial Institutions Examination Council. The interagency's procedures permit regulatory regulator flexibility in areas that may not apply to the institutions they regulate. For example, procedures addressing Federal Community Reinvestment Act assessment areas which do not apply to credit unions are excluded from the scope of NCUA's fair lending examinations. The interagency's procedures require examiners to review in sufficient detail in order to understand the organization, staffing, training, record-keeping, auditing, policies, and procedures of a credit union's fair lending compliance management system, and note risk factors. Risk factors may include the following 5 areas. 1, the overall credit union compliance record is weak. 2, prohibited basis monitoring information required by applicable laws and regulations is non-existent or incomplete. 3, the size, scope, and quality of the credit union's compliance management system, including senior management's involvement, designation of a compliance officer, and staffing, is materially inferior to programs customarily found in credit unions of similar size, market demographics, and credit complexity. 4th, the credit union has not updated compliance policies and procedures to reflect changes in law. And 5th, the fair lending training is non-existent or weak. Now, NCUA's review of compliance management systems focuses on the following. 1, determining whether the policies and procedures of the credit union enable management to prevent or to identify and self-correct illegal disparate treatment in the transactions that relate to its products and services. And 2nd, obtaining a thorough understanding of the manner by which management addresses its fair lending responsibilities with respect to A, the credit union's lending practices and standards, B, training and other application processing aids, C, guidance to employees or third parties in dealing with credit union members, and D, its marketing and other promotion of products and services. And I will now turn the presentation over to Program Officer Matt Nixon to discuss fair lending examination and supervision context observations. Matt?
Thank you, Gail. As Gail mentioned, I'll now discuss observations noted in NCUA's fair lending exams and supervision contacts. Through this webinar, NCUA's Office of Consumer Protection intends to highlight the fact that a credit union's compliance management system, or CMS, is the foundation for effective fair lending compliance. Weaknesses in CMS can result in violations of law or regulation and associated harm to consumers. As Gail previously mentioned, each NCUA fair lending examination and supervision contact includes a review of the credit union's CMS. An effective CMS includes a number of elements: board of directors and management oversight, policies and procedures, training, monitoring and corrective action, compliance audit, and member complaint response. Compliance management systems are most effective when several conditions are met. I'll mention a few of them. First, compliance is part of the day-to-day responsibilities of the credit union's management and their employees. Second, the credit union self-identifies issues and initiates corrective action. Third, the credit union manages relationships with third-party service providers to ensure that these providers effectively manage compliance with federal consumer financial laws. For more information about CMS, refer to the webinar, Fair Lending and Home Mortgage Disclosure Act Compliance, from February 20th, 2015, which is archived on NCUA's website at ncua.gov. Now I will discuss some specific observations about fair lending compliance management based on experience performing fair lending exams and supervision contacts. First, it is important for credit union policies and procedures to fully address management's fair lending practices and expectations. Omitting key information could lead staff to misinterpret and misapply credit union guidelines. Most credit union fair lending and/or general lending policies include a statement of non-discrimination. We've observed that a non-discrimination statement that is very general or lists some but not all prohibited bases could cause staff to overlook or misapply certain ECOA or FHA protections. An example of a non-discrimination statement that is very general is a statement that simply says, "We will not discriminate on a prohibited basis," without listing prohibited bases for discrimination. An example of a non-discrimination statement that omits some prohibited bases is a statement that the credit union will not discriminate on the basis of race, color, religion, national origin, sex, marital status, or age. Such a statement omits other prohibited bases for discrimination. The fact that all or part of the applicant's income derives from a public assistance program, the applicant's exercise in good faith of any right under the Consumer Credit Protection Act, and for real estate loans, familial status, and handicap. Relatedly, policies that omit key requirements under ECOA or FHA could lead staff to inadvertently discriminate against protected borrowers. Let's say a credit union's policy requires an applicant to have 2 years of employment. Even though the credit union's primary concern is that an applicant demonstrates stable income, not stable employment, the policy fails to address the underwriting of loans to applicants with non-employment income, such as retirement pensions or Social Security disability income. A loan officer following the letter of the policy could inadvertently discriminate on the basis of age when failing to consider a retiree's pension, or on the basis of receipt of public assistance income when failing to consider Social Security disability income. An effective CMS will ensure these concerns are addressed not only in credit union policies and procedures, but also through oversight, training, monitoring, and audit programs. A second observation is that an effective CMS ensures policies and procedures address the underwriting-related requirements in fair lending laws. For example, Regulation B and its staff commentary address rules concerning the evaluation of applications. Generally, a creditor may not take a prohibited basis into account in any system of evaluating the creditworthiness of applicants, and a creditor must evaluate married and unmarried applicants by the same standards. Exceptions may apply when considering the marital status of an applicant or joint applicant for the purpose of ascertaining the creditor's rights and remedies applicable to the particular extension of credit. For example, in a secured transaction involving real property, a creditor could take into account whether state law gives the applicant's spouse an interest in the property being offered as collateral. The regulation generally prohibits policies that evaluate joint applicants differently based on marital status, such as averaging the credit scores of married co-applicants while using the lower of two credit scores for unmarried co-applicants. Such policies and practices demonstrate weaknesses not only in credit union policies and procedures, but likely implicate inadequate oversight, training, and an inadequate fair lending audit program. Additionally, Regulation B and its official interpretations address conditions under which a creditor may require the signature of a spouse or other person. A creditor generally cannot require the signature of an applicant's spouse or another person other than a joint applicant on any credit instrument if the applicant qualifies under the creditor's standards of creditworthiness for the amount and terms of the credit requested. This is the case even if the creditor applies the requirement without regard to sex, marital status, or any other prohibited basis. Some exceptions may apply, such as when the applicant resides in a community property state or if the applicant is relying on property located in such a state. The signature rules ensure that qualified applicants are able to obtain credit in their own names. Thus, when an applicant requests individual credit, a creditor generally may not require the signature of another person unless the creditor has first determined that the applicant alone does not qualify for the credit requested. Policies that explicitly require or prohibit using a spouse as a cosigner or require a cosigner even though the applicant is individually creditworthy likely violate Regulation B. Again, an effective CMS will ensure these concerns are addressed not only in credit union policies and procedures, but also through oversight, training, monitoring, and audit programs. Many would argue that it is in a credit union's DNA to treat members fairly. Credit unions generally understand and subscribe to the non-discrimination requirements addressed in ECOA and FHA. Credit unions have historically avoided lending practices that could lead to allegations of unfairness or unequal treatment, such as loan officer incentives tied to costlier products or tied to the rate of the loan. While the notion of fairness and treating all members equally may be at a credit union's core, credit unions may still get tripped up on compliance with the technical provisions of fair lending regulations. For example, lending staff know that an adverse action notice is generally required after denying a member's loan application. Some may be unaware that an adverse action notice can be triggered by verbal communication with the member, even when no written application is submitted. If a member inquires about a loan and the loan officer, following a review of the member's credit report or based on knowledge of the member's credit situation, advises the member that a credit application will likely be denied, then the loan officer has made and communicated a credit decision, and notification of action taken is required. In a second example, let's say a credit union conditions approval of a home loan on an appraisal showing a value of $300,000. The appraisal comes in at $250,000. The loan officer advises the applicant of the lower than expected appraisal and tells the member that he will need to come up with an additional $50,000 for closing. The member tells the credit union to withdraw the application. Under Regulation C, the credit union should report the application as denied and not withdrawn on its HMDLR because it denied the application based on the original terms requested. Under Regulation B, the credit union would issue an adverse action notice. In an effective CMS, policies, procedures, and training cover compliance with technical provisions of fair lending regulations. A strong fair lending audit function will identify where gaps exist and where technical provisions have been misinterpreted and misapplied. While indirect auto lending has not been a special focus of NCUA's Fair Lending Examination Program, we have noted under an effective CMS, policies and procedures address oversight of third parties, such as indirect auto dealers. ECOA defines a creditor to include not only any person who regularly extends, renews, or continues credit, but also any assignee of an original creditor who participates in the decision to extend, renew, or continue credit. Regulation B further provides that a creditor means a person who, in the ordinary course of business, regularly participates in the decision of whether or not to extend credit, and expressly includes an assignee, transferee, or subrogee who so participates. These are long-standing definitions within ECOA and Regulation B. Indirect auto lenders are creditors under ECOA and Regulation B if, in the ordinary course of business, they regularly participate in a credit decision, which may include influencing the credit decision by indicating whether or not it will purchase the obligation if the transaction is consummated. A consideration for auto lenders covered as creditors under ECOA is whether and under what circumstances they are liable for pricing disparities on a prohibited basis. When such disparities exist within an indirect auto lender's portfolio, lenders may be liable under the legal doctrines of both disparate treatment and disparate impact. Credit unions involved in indirect auto lending should understand the fair lending risk exposure involved with providing broad pricing discretion to their indirect auto dealers without commensurate oversight and analysis. NCUA addresses expectations for oversight of third-party service providers and indirect auto dealers in NCUA letters to credit unions 01 CU 20, 07 CU 13, and 10 CU 15. The letters advise credit unions to ensure compliance with state and federal laws and regulations and contractually bind third parties to compliance with applicable laws. Similarly, Supervisory Letter 07-01 states that since credit unions may ultimately be responsible for consumer compliance violations committed by their agents, credit unions should be familiar with the third party's internal controls for ensuring regulatory compliance. The letters tell credit unions to adopt monitoring and reporting practices. Letter to Credit Unions 01 CU 20 states that failing to do so constitutes an unsafe and unsound practice. The letters tell credit unions that an improperly managed or loosely controlled indirect auto lending program can quickly lead to unintended risk exposure. Due diligence in indirect auto lending includes a planning process which assesses risks, both initial and ongoing. It also includes having comprehensive written policies addressing all facets of the indirect lending program, including underwriting and monitoring. Allowing broad pricing discretion for a credit union's indirect auto dealers is an example of a policy or practice that poses fair lending risk. An effective CMS provides for adequate oversight of loan pricing by auto dealers with which a credit union works. The final observation relates to fair lending audit programs. A fair lending audit program provides credit union officials with a determination of whether adopted policies and standards are being implemented in a way that complies with applicable laws or whether there are systemic violations. In an effective CMS, the audit function identifies any significant gaps in board policies and standards. In a credit union within an effective CMS, we would not expect to see frequent unexplained or unsupported loan policy exceptions or systemic errors on a credit union's HMDLR. For the same reason, a credit union does not have its accounting staff audit the credit union's financial statements, a credit union should not have lending staff evaluating whether or not lending decisions appear to violate fair lending laws. The function requires independence from the credit union's business unit. There is a role for the business unit to play in fair lending oversight. For example, loan staff can perform a second review of approved and denied loans to confirm credit union policies were followed, but it is the audit function's role to review areas where a level of independence is required. Fair lending audit activities may be tailored to the size and complexity of the credit union and the loan products it offers. Also, audit results should lead to appropriate and timely corrective action. You can learn more about compliance with fair lending laws through resources NCUA makes available on the Fair Lending webpage of NCUA's Consumer Compliance Regulatory Resources web pages. Resources include a fair lending guide, webinars, the interagency fair lending examination procedures, answers to frequently asked questions, and more. That concludes my portion of the presentation. Jamie Goodson will now talk about unfair, deceptive, or abusive acts and practices. Jamie?
Thanks, Matt. The concept of unfair or deceptive acts or practices is not new, but it certainly has received renewed attention in recent years. Also, the concept of an abusive act or practice has emerged at the federal level through changes made by the DoddFrank Wall Street Reform and Consumer Protection Act. Although examining for unfair, deceptive, or abusive acts or practices is not necessarily an NCUA focus, it is helpful for credit unions to understand some specific standards developed for determining whether those terms apply to a particular act or practice. For many years, the Federal Trade Commission Act required all businesses that engage in transactions with consumers not to engage in unfair or deceptive acts or practices. The common term UDAP stands for the phrase unfair or deceptive acts or practices. With the passage of the Dodd-Frank Act in 2010, Congress also prohibited abusive acts or practices. The addition of abusive to unfair and deceptive added an extra A to the acronym. We will discuss the FTC Act and Dodd-Frank Act standards as described in publicly available materials issued by the Federal Trade Commission and the Consumer Financial Protection Bureau. Although we're discussing federal laws, all states have some type of similar law or regulations with which your credit union may have to comply. Okay, we'll start by talking about the standards for being an unfair act or practice. To be unfair, an act or practice must result in substantial injury to consumers, and the harm or injury cannot be reasonably avoided by consumers. Also, the benefits to consumers or competition cannot be greater than the consumer injury. In determining whether an act or practice is unfair, the FTC or CFPB may consider established public policies. Now on to deception. Although neither the FTC Act nor the Dodd-Frank Act contains a definition of deception, and neither describes what makes an act or practice deceptive, the FTC listed the 3 elements of deceptive conduct in a policy statement attached to a decision it made in a 1984 case. For an act or practice to be deceptive, there must be a representation, omission, or practice that is likely to mislead a consumer. Whether that exists must be considered from the perspective of a reasonable consumer under the specific circumstances. Lastly, the representation, omission, or practice must be a material one. That means it's one that is likely to affect the consumer's choice of or conduct regarding a product. That appears in an FTC policy statement, and CFPB adopted the same standard in a bulletin in 2013. Now on to abusive acts or practices. Prior to the enactment of the Dodd-Frank Act, no federal law expressly prohibited the use of abusive acts or practices in connection with consumer financial transactions. The Act lists the specific elements that must be present for CFPB to declare an act or practice abusive. To be abusive, the act or practice must materially interfere with the consumer's ability to understand a term or condition of a financial transaction. Alternatively, an act or practice may be abusive if it takes unreasonable advantage of a consumer's lack of understanding of the material risks, costs, or conditions of a financial transaction, if it takes unreasonable advantage of a consumer's inability to protect his or her interests when selecting or using a financial product or service, or it takes unreasonable advantage of the consumer's reliance on a person covered by the relevant provisions of the Dodd-Frank Act. So that's an overview of publicly available standards regarding unfair, deceptive, and abusive acts or practices. And please feel free to contact OCP's Division of Consumer Compliance Policy and Outreach with any questions related to fair lending or UDAP that are not addressed in the question and answer portion of this webinar. Our contact information is shown. Now we will open the floor to questions from our audience. Ken, I believe we have some questions about consumer complaints.
Thank you, Jamie. Yes, we'll go to our first question to Morgan Rogers, Director of the Division of Consumer Affairs. Morgan, when will the portal be available to credit unions?
Thanks for that question, Ken. As a reminder, the Consumer Assistance Center portal was rolled out for consumers in early September, and we will be rolling out the portal for credit unions in November, sometime in November. And the portal was created to submit complaint response information securely, check the status of complaints filed with NCUA concerning credit unions, institutions. And the use of that portal is strictly voluntary. Also, in addition, when we do release the portal, we'll release a video for credit unions as well as a Consumer Assistance Center guide that will walk credit unions through how to access the portal, how to use the portal. So there's a lot of resources that will become available once we do go live in November.
Thanks, Morgan. Another question regarding the portal. Will the portal also include complaints that are initially submitted through the CFPB?
All of the complaints that are available in the portal are consumer complaints that are sent to NCUA. Oftentimes, the CFPB will receive consumer complaints that do not fall within their purview, whether that's it's because the institution falls under the 10 billion mark. So if they refer a complaint to us, then yes, that complaint will end up in the portal because we will then send that complaint to you and handle it as a consumer complaint that NCUA has received.
And how will NCUA contact credit unions regarding access to the portal?
Again, the portal will be ready to go in November, and so we'll do quite a few things. So again, there's that video. There's the guide, but we will let credit unions know through an NCUA Express message, as well as a couple different media pieces, including press releases. So if you consistently check ncua.gov, there'll be information there. Also, again, press releases, and you should be receiving an NCUA Express message as well about it.
Thank you, Morgan. And now back over to Jamie with additional questions.
Thanks, Ken. Yes, we have some fair lending questions for Matt. In your presentation, you mentioned that credit unions cannot discriminate on the basis of familial status in real estate lending. What exactly is familial status?
Jamie, familial status is defined as children under the age of 18 living with a parent or legal custodian, pregnant women, and people securing custody of children under 18. And under the Fair Housing Act, while we review compliance related to real estate lending, the Fair Housing Act is broader than just lending. So where you will sometimes see enforcement actions related to familial status will be in the rental market, by renting apartments, homes to, or I guess I should say, of landlords and owners failing to rent to families or people with children.
Thanks, Matt. Another question on fair lending. If our credit union is selected for a fair lending examination, do you come in with the regular safety and soundness exam team?
We coordinate our exams and supervision contacts with the NCUA regional offices. So before we make a decision to go into a particular credit union, we will contact the regional office and we'll ask for input from the field staff that are associated with that particular credit union. That said, we issue standalone examination reports, and our examinations are standalone exams. So In rare instances, the safety and soundness exam team will ask us to co-participate with them, but generally we perform our fair lending examinations separately from your regional safety and soundness exams.
Thanks, Matt. Here's a question a bunch of people may be wondering. How will recent rule changes to the regulation implementing the Home Mortgage Disclosure Act affect credit unions?
So, as most in the audience are probably aware, on October 15th, the CFPB finalized changes to the Home Mortgage Disclosure Act. Many of the changes were mandated under the DoddFrank Act, and while the changes are in a final form now, most changes to reporting requirements will not take effect until 2018, with credit unions filing those reports in 2019. The new rule eases the burden in some cases, so especially with regard to small credit unions. Small credit unions that originate fewer than 25 home purchase loans will no longer have to report HMDA data. But for those not excluded by low volume thresholds, open-end lines of credit may no longer be optionally reported. Credit unions that originate 100 or more open-end lines of credit annually must report those transactions. The new rules add additional data reporting elements such as applicant age, credit score, debt ratio, a combined loan-to-value ratio, discount points paid, and the name of the automated underwriting system used to evaluate the application if a credit union uses an AUS. Credit unions will report HMDA data under the new rule using a new web-based submission tool, and beginning in 2018, credit unions will no longer be required to provide a disclosure statement or modified loan application register to the public upon request. Instead, they can just provide notice that the information is available through the CFPB. And the CFPB has made available extensive information related to the new HMDA rule on its website, and you can access that at consumerfinance.gov/regulatory-implementation/HMDA.
Thanks, Matt. And you also can reach CFPB's webpage through NCUA's Fair Lending web pages on the Consumer Compliance Regulatory Resources web pages. I think we're ready for some, we'll switch back to consumer complaints. Ken?
Thank you, Jamie. First question, another question for Morgan. Can credit unions submit complaint responses via email?
Yes, use of the portal is not voluntary, so credit unions are welcome to use of the portal is voluntary. So credit unions are welcome to respond via email. No, there's two ways to do that. You will receive emails from us that will have a reference number and a subject line in them. So if you hit respond to those without changing the subject line and reference number, and again, this is in the guide and all the handouts that we'll give people who want to use the system, you will, if you hit respond, it'll go right back into the portal. But in general, if you want to stay outside of the portal altogether, you can always send an email and any response to consumeraffairs@ncua.gov. And again, as a friendly reminder, NCUA can't verify the security of that transaction if it's outside the portal. So you need to do what you should do at your organization to secure that communication.
Thank you, Morgan. Another question to you about the complaint process. Who should the credit union contact if they want to discuss a pending case with NCUA?
If it's a case that was received after August 24th, they're welcome to, well, in any situation, they're welcome to call the Consumer Assistance Center at 800-755-1030, and we'll be happy to talk to you about a consumer complaint. Again, complaints in the portal are from August 24th forward. Any complaints prior to that, you should call regardless.
Another question regarding the process. Are credit unions required to track internal complaints received via phone, email, etc.?
Complaints that are not sent to NCUA?
In regards to complaints, are they required to track internal complaints?
Yeah, I mean, credit unions should always have a good compliance management system on hand. So whether the complaint comes to NCUA or not, or it's just something you receive and it comes to a teller or it comes through your telephone, you should always track every single complaint that comes through the door, because you never know when you try to resolve something on the first hand and then a consumer could come to us secondarily and ask us to try to resolve it also by submitting a complaint. So you want to make sure that you are keeping track of all the communications you have with all of your members.
And another question regarding, here we go. For state-chartered credit unions that are federally insured, are the complaints submitted by the consumer only to the state or to the NCUA? Who is ultimately responsible for the resolution?
Thanks, Ken, for the question, and there's a couple of matters involved there. As an initial matter, our Consumer Assistance Center handles complaints submitted by consumers about federal credit unions, and only in certain circumstances, when certain laws are involved, would in fact we investigate a matter because we have jurisdiction regarding a state-chartered credit union. So indeed, the state supervisory authority is responsible for supervising and handling that complaint matter. Now, with regard to the issue of resolution, again, we are encouraging the credit union to try to resolve the matter with the consumer. But indeed, if it's a state-chartered credit union, unless it's a specific law that NCUA enforces in that state-chartered credit union, the matter would be handled by the state supervisory authority. And so the complaint would be referred to the state supervisory authority, and the matter would be closed with regard to the Consumer Assistance Center. Thanks.
Thank you, Gail. A question for you, Morgan. Where does the Consumer Assistance Center obtain the contact information for supervisory committee officials?
Any contact information that we receive or utilize in the Consumer Assistance Center comes through the CU online profile or the credit union online profile system, which credit unions themselves update. So, you want to make sure that you check your profile, make sure all your information is up to date and correct there, and that's where we will pull our information from. I also see here that we have a number of questions about the portal and how it's used and whatnot. So we will go ahead and throw those questions over to our office director, Gail Laster, to answer.
Thanks, Morgan. All I just wanted to say was we're not particularly going to go into each of those questions because, as Morgan indicated, we haven't started the process for signing up credit unions. Once we do, we will have a press release. We will have frequently asked questions and answers. We will have a written credit union user portal user guide, and we will have a video. So indeed, it's a little bit premature to go into answering these questions, but we're glad to see so much interest in using the portal because we do think it will be a help to credit unions to provide a secure method of communicating with the Consumer Assistance Center. So stay tuned, and we appreciate your questions, and we believe that they will be answered when we put out our materials in November. Thanks.
Thank you, Gail. And now back over to Jamie with some additional questions.
Thanks, Ken. We have a question about equal housing opportunity signage, and the question is about an institution that has several branches with all mortgages done centrally at just one branch. In that case, does the equal housing signage need to be visible in all the branches or just the one where the mortgage applications are taken?
Okay, so equal housing signage must be prominently displayed so it's readily apparent to all persons seeking to engage in real estate-related transactions or who are seeking real estate loans. The signage must be posted and maintained at all credit union business locations which participate in real estate-related transactions.
Thanks, Matt. So more on the notices. Do you need to have a non-discrimination notice posted on solicitation mailings for a mortgage refinance?
Yes. Any federal credit union that advertises real estate-related loans must prominently indicate in such advertisements in a manner appropriate to the advertising medium and format used that the credit union makes such loans without regard to race, color, religion, national origin, sex, handicap, or familial status. Now, with respect to written and visual advertisements, a credit union can satisfy the notice requirement by including in the advertisement a copy of the logo type, which is shown in the regulation with the legend equal housing lender or equal housing opportunity.
Okay, thanks, Matt. Now we have a question about supervision contacts, which we perform off-site. And the question is, do you normally perform a supervision contact prior to a fair lending exam?
Typically, so when we select supervision contacts and fair lending examinations, we do so on a risk basis. And the examinations demonstrate higher fair lending risk than the supervision contacts. So we don't perform a supervision contact with the expectation that it's going to lead into an examination. That said, if we find concerns during a supervision contact that we feel we need to review on-site or that we could only review on-site, then we may perform a follow-on exam. And with supervision contacts, there is no transactional testing. So we may perform a supervision contact and determine that we really need to do transactional testing to answer certain questions. And it would be in those type situations where we might perform a follow-on examination.
Thanks, Matt. I think we're ready to turn the mic over to Ken for another question about consumer complaints.
Thank you, Jamie. Yes. Question to Morgan regarding the complaint process. Are the complaints screened that go into the complaint center?
All the complaints that are received by the Consumer Assistance Center, they are not screened. We take what we are given. We obviously will look at them to see if they're applicable under federal financial consumer protection laws and regulations in terms of NCUA's jurisdiction and whether or not we can handle them ourselves. But every single complaint that is submitted to NCUA does go to the Consumer Assistance Center for handling.
And why did NCUA make these changes to the complaint process? We made these changes because we recognize that credit unions really value their members and value the relationship with their members and want the opportunity to try to resolve those complaints directly with their members. So we wanted to afford credit unions the opportunity to do that within a reasonable time frame of 60 days. We hope by doing that, credit unions are able to effectively manage a relationship with their members and maintain a good relationship with their members by attempting to resolve the majority of those issues before they become a problem. Also, oftentimes we recognize that consumers have not attempted to contact the credit union about complaints. And so sometimes they come first to us before they go to the credit union. And again, we wanted to give the credit union the opportunity to be aware there was a complaint, that there was a problem, and give them the opportunity to try to resolve it before NCUA got involved. Another question regarding the complaint process. What if the credit union does not agree with NCUA's complaint determination or findings?
As we stated in the presentation, both the consumer and the credit union have the opportunity to appeal a determination made by NCUA. Now, it's important to recognize that in the first phase, that attempted resolution phase, NCUA does not make a determination. That's the opportunity for the credit union to resolve that matter directly with the member and simply notify NCUA that it has done so. If we get to the second phase, which is that investigation phase, and we initiate a complaint, and again, that could happen for one of three reasons, which is we either didn't receive a response from the credit union in 60 days, the consumer disputed that response, or the credit union indicated it couldn't resolve it, then NCUA will do an investigation, which is a little bit like our older process you may be familiar with, and we will render a determination. If at any point, if you get that determination letter in phase 2 and you don't agree, you have 30 days as the credit union to appeal it and say you don't agree. The consumer also has that right as well. And then as a last step, obviously there is the Ombudsman's office. If you don't want to file an appeal with us, you can always approach the NCUA Ombudsman, who will also secondarily look at the complaint.
Thank you, Morgan. Another question about process. If the credit union received the NCUA letter about the complaint and took care of the matter over the phone with a consumer, can the credit union just send NCUA an email to let you know it is resolved?
Yeah, the answer says yes and no. While we definitely appreciate your efforts to resolve the matter with the consumer, which is, again, the goal of the system, credit unions need to be aware that in the letter to consumers, we indicated to them that they would receive a written response from the credit union about the matter. Even if that's just a summary of your phone call or a summary of your interaction, verifying that, you did or didn't take this particular action, or you were or weren't able to resolve it. We do, recommend that you communicate with the consumer and then CC NCUA on that communication. Because again, if a consumer says, well, no, I never got that written notification, and NCUA, you told me you would, that's where we have to make sure we have records that the credit union took the appropriate action.
Thank you very much, Morgan. Now back over to Jamie Goodson.
Thanks, Ken. Matt, we have a question about government monitoring information, which is demographic information about applicants. The question is a credit union required to gather government monitoring information on home equity lines of credit if it does not report home equity lines of credit when it reports data under the Home Mortgage Disclosure Act?
The regulation requires that a credit union who receives an application for credit primarily for the purchase or refinancing of a dwelling occupied or to be occupied by the applicant as their principal residence, where the extension of credit will be secured by the dwelling, must request as part of the application the applicant's ethnicity, race, sex, marital status, and age. And this is under Regulation B, not HMDA. Now, an application for an open-end home equity line of credit is not subject to the Regulation B requirement for collecting GMI unless it is readily apparent to the credit union when they take the application that the primary purpose of the credit line is to purchase or refinance a principal dwelling.
Great, thanks. We have another question related to HMDA, and it's why do you need to collect or request the government monitoring information if you don't have to file HMDA data?
The simple answer is both Regulations B and Regulation C address collection of government monitoring information. So it could be the case that a credit union may be required to collect it under one regulation but not under the other. So for non-HMDA reporters, credit unions that receive applications for credit primarily for the purchase or refinancing of a dwelling occupied or to be occupied by the applicant as a principal residence, where the extension of credit will be secured by the dwelling must collect GMI pursuant to Regulation B requirements.
Thanks, Matt. Now we have a question about member business loans. Do member business loans fall under fair lending requirements?
Member business loans, under some circumstances, fall under fair lending requirements. So the general non-discrimination requirements addressed in Regulation B and the Equal Credit Opportunity Act apply to all loans, consumer, business, real estate. However, some of the technical requirements of Regulation B, I think especially related to requirements for notification, are different for business applicants than they are for consumer applicants.
Okay, thanks, Matt. We'll ask one more about pre-approvals. So in a situation where a borrower has asked for pre-approval and is searching for a home, would the issuance of a pre-approval letter be enough to meet the 30-day decision requirement for ECOA, even if you can't move forward without a property?
Yes. A pre-approval is considered an application under Regulation B, and so the written commitment satisfies the 30-day notification requirement.
Okay, thanks. Ken, are you ready to take another question on consumer complaints?
Yes, thank you, Jamie. We have a question, this one for our Office of Consumer Protection Director, Gail Laster. How do you recommend handling complaints that have no merit or irrational? Example, a member shares their online banking information.
Thanks for the question, and indeed, we understand that this happens. But as we recommended throughout this webinar, we should have a process that allows you to note the complaint. And again, if you can make out whether or not there is a rational complaint made, note that, and what the response would be, that whether or not you believe it has no merit and why. But we do indeed want to make sure that we document that the complaints that we received, recognizing that not all of them will have merit, but that it is important to note what was received and the action that the credit union took. And that's the same case here with the Consumer Assistance Center. We note that the complaint was received, the action we took, but we certainly do recognize that in many occasions you're dealing with folks who may not be making out an articulable complaint, or as you indicated, you believe that the complaint has no merit. So thank you for the question.
Thank you, Gail. And a question for Morgan Rogers. Will NCUA provide guidance to credit unions on how to use the portal?
Yep, as Gail indicated, and as well as we discussed earlier in the webinar, there are a number of different publications that we will be putting out, including a video that walks credit unions through step-by-step on how to use the portal. There's a credit union portal user guide that we've developed that accompanies that video. Again, we'll have press releases. We've already put out the letter to credit unions that walks credit unions on through the process changes. There'll be a series of FAQs that accompany our media releases, and there was also a best practices guide that came with the letter to credit unions entitled Responding to Consumer Complaints. So there's a bit of guidance out there now, and there'll be a whole bunch more coming in the near future when we go live with the portal.
Thank you very much, Morgan. Jamie, back over to you.
Thanks, Ken. We have another question about fair lending. Is an annual audit required for fair lending, or is it a best practice to conduct an annual audit?
One thing I should probably clarify. In the presentation today, we talked about an audit function and as a component of a credit union's compliance management system. And then separately, we talked about monitoring and corrective action as another component. So what we generally are, recommending conceptually is that auditing function is a series of actions that a credit union takes that are independent from the business unit, and they may occur throughout the year. Generally, the auditing function is more formal but less frequent than monitoring and corrective action, which may be conducted by the business unit. So there is no annual audit requirement for fair lending, but what we're trying to communicate to credit unions is not, by talking about an auditing function, is not a standalone audit that a credit union completes and then they forget about for a year, 18 months. It's actually a series of actions that they take to review compliance with fair lending.
Thank you, Matt. That's all the time we have for questions, but I want to thank you all for joining our webinar to hear about NCUA's enhancements to its Consumer Assistance Center processes for handling consumer complaints, and also for information about effective oversight for compliance with fair lending laws and regulations. The presentation provided information about how you can contact both the Division of Consumer Affairs about consumer complaints and the Division of Consumer Compliance Policy and Outreach about fair lending. And we encourage you to reach out via email or phone using the information provided. Please enjoy the rest of your day and look forward to interacting with you in the near future. In the interim, you can visit NCUA's Consumer Compliance Regulatory Resources webpage on ncua.gov and get information not only about fair lending, but also about mortgage rules, credit cards, and a lot that's going on in consumer financial services today. Thanks again. Take care.